Okay, last bonus video here, CC students. I thought since we talked about these concepts in the other videos that it would be important for me to give you an overview of the steps in a trial. And this is a general statement. We're going to get into more depth in each one of these, but I want to give you an overview of how trials conducted. After the judge selects, and the attorney selected jury, after the jury's seated, we move to opening statements. And notice I say statement here. Some people will say opening argument and closing argument. It's not an argument. The opening statement is a statement of the case. I like to call this like the preview of what the case is going to be about. And the opening statement begins with the prosecution or the plaintiff, the party that has the burden of proof. When we talk about burden of proof, this party goes first and they give their opening statement. And the role of the opening statement is to give a preview to the jury of what your witnesses are going to say, what the evidence is going to show, what the burden of proof is in the case, and how all of that weaves together. And you may, at this time, talk about your theme as well. And you have to get the attention of the jury. It has to be persuasive. This is where you use the rhetoric, the persuasive writing, and the persuasive speech to begin to tell the story about what the case is about. So you give an overview of the case from the prosecution standpoint, what you think the case is going to show, what your witnesses are going to testify. Here's the thing that we'll talk more about in the opening statement video. Whatever you say is going to happen in the trial, you better deliver that if that is what you think is going to happen. So if you say you're going to hear from the police officer who's going to say X, that police officer better say X because you've told the jury this is what's going to happen. If you want to maintain credibility and be open and honest, this is what you need to do. That's why preparation for a trial is so important and working with your witnesses. You know what they're going to say by this point in the case, so it's okay to tell the jury this is what they're going to say. This is what the evidence is going to show. From the defense standpoint, this is a time to begin to talk to the jury about reasonable doubt. This is a time to talk about the burden of proof. And maybe if you have a theory, if you have witnesses that at this point in the case that you know you're going to present witnesses, you could begin to give an opening statement about what those witnesses are going to show, just like the prosecution did. So this is the opening of a case is the opening statement. After both parties have given an opportunity to have an opening statement, we move to the prosecution's case in chief. And remember we talked about burden of proof? Prosecution has a burden of proof. Because of fundamental fairness, they have to move forward with the case. How do they present the facts to support their case, to tell their story? They use witnesses, remember? And they use lay witnesses, they use expert witnesses. They also use documents, and they also use exhibits, right? You can't get a document, though, in without a witness. So in order, if you have a piece of information that you want to present to the court, you have to use the witness to get that in. So in your mock trial packet, you should be told that these are the witnesses for the prosecution, and these are your witnesses. So you would ask, like we talked about, direct examination questions. What is your name? Prosecution would ask direct examination questions, talk about the evidence, all with one purpose in mind, continuing to maintain your theory of the case, move that forward, weaved in with your theme. And remember in the video we talked about the burden of proof, and you have to prove each and every element. These witnesses have to go back towards the elements of the case. If the witness doesn't help you tell the story and doesn't help you prove the elements of the case, leave them at home. You don't need them. So these witnesses on direct examination that you're calling, these are your witnesses, they have to help you prove the elements of what you're saying that the defendant did. After you had a chance to ask questions for your witnesses, the other side, the defense, would get a chance to cross-examine them. And that's where they would ask leading questions to begin to poke holes in the case. And that's things that you can do, and you'll find this through your analysis of the case. After the prosecution has called all their witnesses and presented all their documents and their evidence that they want to present in the case, they move to resting. That means that they have no other witnesses to call. They're done with their case, and the case moves to the defense. Now, in your mock trial, the defense will have witnesses, and they will call those witnesses. Just like the prosecution did, the defense witnesses will be called by the defense, and the defense now asks direct examination questions. They're their witnesses, and those are the open-ended questions. What is your name? What do you do? Why are you here today? What do you have to tell us? Did you prepare an exhibit or a document to support your testimony? After the defense gets a chance to ask their witnesses direct examination questions, now the prosecution moves to cross-examining those witnesses. This is where you ask the leading questions, questions to discredit the testimony that's been given by the defense. After the defense calls all their witnesses, they rest. Some court cases we have rebuttal, where you can call rebuttal witnesses. I don't believe in this mock trial we're having rebuttal witnesses, but if there was, then we would move to calling other witnesses. But for this purpose, we're just going to have the defense call witnesses. Finally, we move to closing argument after the defense is done. And in our closing argument, unlike the opening statement where the prosecution went first, the defense goes first. The defense gets up and they begin to make argument. Now, this is where you argue. You say, ladies and gentlemen of the jury, you should not believe this witness because of these reasons. There was problems with their report. They made mistakes. They're lying. Ladies and gentlemen of the jury, use your common sense to not believe this witness. That's some of the arguments. And in our argument, the defense may say is that remember the whole burden of proof? The prosecution didn't meet their burden of proof. These are all closing arguments that the defense, may raise. Or, in fact, they may say, the defendant did break the law, but they were justified in doing it. They had an affirmative defense. After the defense gives their closing argument, the prosecution now gives their closing argument. And they say why the evidence supports their theory and the theme of the case, why you should believe the witnesses, not injecting their own opinion, not saying, I don't stand up as an attorney and say, I believe this is what happened. You say things like, ladies and gentlemen of the jury, ladies and gentlemen of the jury, the evidence supports that this happened this way. Use your common sense to analyze the evidence to say this is what happened in this case. And all of that goes towards the elements of the case. And those are the closing arguments. Remember, in the case, we have to prove each and every element of the case. One last thing that's very important. In your case, I recommend that every opportunity you have in the opening statement and the closing argument, you should be telling the jury what you want them to do. So from a prosecution standpoint, right? What do you want the jury to do? And you should be able to discuss that and figure that out. From the defense standpoint, what do you want the jury to do? Now you get to the closing argument. It's the end of the case. You need to empower them to do what you want them to do. You ask them to do something. So for the prosecution, what are you asking the jury to do? From the defense, what are you asking the jury to do? You better tell them what to do. Don't leave that out. That's a very important thing. I can't tell you to tell them what to tell them to do, but review your packet. And this goes to your theory and your theme and what we're trying to do. There's a general overview of the steps in a trial. Break those all down in separate videos and give you some tips and tricks on how to do this. Have a great night. Thanks. Bye.